Good afternoon, and thank you for joining our webinar today, What the New CFIUS Rules Mean for Real Estate Deals. My name is Gina Mavica, and I'm a partner in the real estate group at Baker Hostetler, based in the New York office. I regularly represent clients on acquisition, sales, and development of real property throughout the United States. In addition, I represent both borrowers and lenders in a wide range of financing transactions. I'm pleased to be co-hosting this webinar today with my colleague, Barbara Linney. Ms. Linney is a partner and co-lead of Baker Hostetler's International Trade and National Security Practice Team, based in our Washington, D.C. office. She has been advising U.S. and foreign clients on international trade and business issues for nearly 30 years. She serves clients across a broad spectrum of industries, with particular focus on the defense, aerospace, oil and gas, maritime, and medical device industries. Her practice involves representing clients before various federal agencies, including the U.S. Departments of Commerce, Defense, and State, as well as the U.S. Department of the Treasury's Office of Foreign Assets Control, which everyone knows as OFAC, and Committee on Foreign Investment in the United States, known as CFIUS. Ms. Linney regularly advises clients on a wide range of issues, including U.S. export and import controls imposed by various acts and regulations. She also advises on economic sanctions and trade embargoes administered by OFAC and the U.S. Department of State. In addition, she regularly counsels clients on the defense security requirements imposed by the Defense Counterintelligence and Security Agency, proposed acquisitions under review by CFIUS, and related national security issues. Ms. Linney is admitted to practice in the District of Columbia in New York. She is also a member of the Law Society of Alberta, Canada, and the Law Society of England and Wales. She's involved in various professional and community organizations, including the Association of Women in International Trade and the Society for International Affairs. So I'm very happy to have Barbara with us. A few housekeeping matters I'd like to bring to your attention before we get started. This presentation will last approximately 1 hour and is available for 1 hour of CLE credit in California, Florida, Georgia, New York, Ohio, Pennsylvania, and Texas. New Jersey credit is available via reciprocity. If there are any other states of interest, credit can be applied for as requested. If you are going to be applying for CLE credit, there will be 2 separate codes that will appear in the slide deck during this program. I'll be sure to point those out, but please make sure to write down these codes. You will need them. There will be a brief CLE questionnaire immediately following the program's conclusion. Please be sure to stay logged into the presentation system for this questionnaire to appear, and please make sure to answer all of the questions. Regarding the program, if you have any questions during the presentation, you can type your questions in the bar on the right side of your screen in the questions area. We'll try our best to answer them at the end of the program, time permitting. If not, we plan to follow up with you after the webinar to answer these questions. There will also be emails provided in the slides where you can direct your questions to us after the presentation if you should have any questions. Also, the slide deck and a recording of the webinar will be sent to all attendees as well, so you'll have the materials. With that said, I think we can begin our presentation. I am going to direct a few questions to Barbara throughout. I think we should start with what we're doing here today. What is CFIUS and how will it become involved in real estate transactions going forward?
Well, thank you, Gina. So CFIUS, the Committee on Foreign Investment in the United States, is an interagency body. It's headed by the U.S. Department of the Treasury, and it has the authority to review transactions for national security risks. Now, prior to some legislation that was passed in 2018, known as FIRRMA, or the Foreign Investment Risk Review Modernization Act, CFIUS had authority to review transactions only if they resulted in the control of a U.S. business by a foreign person, and these were known as covered transactions. But effective February 13th of this year, under the new authority granted to it by FIRRMA, CFIUS has jurisdiction to review certain real estate transactions, and these are known as covered real estate transactions. However, it's important to note that unlike under the new rules that came into effect on the same date with respect to acquisition of control or other rights in U.S. businesses, the new real estate rules do not impose mandatory filing requirements.
So, I mean, I think we can sort of anticipate the next question, right? And I would anticipate my clients asking me, well, if it's completely voluntary, then why would I want to go about notifying CFIUS of a deal?
Okay. Well, that's a very good question, Gina. And of course, people ask that question all the time. The reason is that going through the process of CFIUS review does offer a benefit that's known as a safe harbor. Once CFIUS has completed all action with respect to a covered real estate transaction, or the president has announced that he or she will not exercise its authority under Section 721 of the Defense Production Act with respect to a covered real estate transaction, then the parties receive a safe harbor with respect to that transaction. And that means that the authority granted to the president to suspend or prohibit the transaction, even post-closing, will be terminated with respect to that transaction. But if parties do not submit their transaction to CFIUS for review and they don't obtain a safe harbor, then they do run the risk that even post-closing, CFIUS could reach out and ask to review the transaction, and there could be a risk that they would be required to unwind the transaction.
So if the parties want to obtain the safe harbor, then are they able to bring any real estate transaction before CFIUS?
Well, no, there are only certain real estate transactions that CFIUS has been granted jurisdiction to review. And these are known as covered real estate transactions. So in order to be a covered real estate transaction, the transaction must involve the purchase or lease by or a concession to a foreign company or individual who is not an accepted investor of covered real estate. And under the new rules that apply to transactions that become legally effective on or after February 13th, these are the sort of scope of transactions that are subject to CFIUS jurisdiction. And I think we'll talk a little bit more about this accepted real estate investor concept a little later in the program, but it's important to note that if the investor is an accepted real estate investor, then CFIUS does not have jurisdiction to review those transactions. The other thing to note is that if the transaction involves real estate that's part of a U.S. business, the separate rules relating to transactions involving U.S. businesses will apply and take precedence. And I think, as you'll see in the materials that we're going to distribute after this webinar concludes, we will be hosting a separate webinar to discuss those rules in a couple of weeks. Now, the covered real estate includes two broad categories. So in addition to having to have the requirements of a purchase, lease, or concession, and an investor who is not an accepted real estate investor, the real estate involved must be covered real estate. And there are two broad categories, and then the second category of real estate is sort of broken up into four parts. The first category is real estate that is within or will function as part of an airport, or a maritime port. And then the second broad category is real estate that is within certain distances of U.S. military installations. Now, the new rules contain an appendix that's divided into four parts. and these are the lists of the various types of military installations that are subject to these rules, and the distances vary in terms of whether your real estate is going to be covered or not, based upon the type of military installation and the specified proximity. So Part 1 of the appendix includes a list of 131 bases, everything from Army, Navy, Air Force, Marine bases, air stations, some training centers, radar sites, a few research labs, a few other research facilities. And if the real estate that you're looking at is within close proximity, which is defined as within 1 mile of one of these installations in Part 1 of the appendix, then that is covered real estate. Part 2 of the appendix lists 32 proving grounds and ranges, a few additional bases, test centers, and if the real estate that's in question is within a so-called extended range, or 100 miles of one of these installations, one of these Part 2 installations, then again, that is covered real estate for CFIUS jurisdiction purposes. Part 3 of the appendix lists 3 Air Force-based missile ranges. 3 is a little bit misleading because these 3 missile ranges span numerous counties in 5 different states, and so Part 3 of the appendix is actually fairly lengthy because it tries to list the scope of these various ranges, getting right down to the county and township level. So if you're within any of these counties or geographic areas near these missile ranges, then again, the real estate will be considered covered real estate and subject to the transaction will be subject to CFIUS jurisdiction. And then finally, Part 4 of the appendix lists a number of offshore range complex and operating areas. Obviously these are located off of various coastal states. And if the real estate is within 12 nautical miles of the U.S. coastline near these complexes and operating ranges, then again, covered real estate and the transaction could be subject to CFIUS review. Now, yesterday I had occasion to be at an event that was attended by senior CFIUS officials, and they are developing what they call a mapping tool that they intend to roll out on the CFIUS website that will allow parties to real estate transactions to key in the longitude and latitude of the real estate that they're interested in and get an answer as to whether that real estate is within one of these degrees of proximity of one of these types of military installations. They say that they are close to rolling that out, weren't able to provide any more detail as to specifically what close means, but certainly when that tool does become available, that will be of tremendous assistance to parties who are attempting to determine whether CFIUS has jurisdiction to review their transaction.
So I imagine that could be sort of one of the issues and diligence that need to be done when you're contemplating review here, because the appendix is quite long, right, with a long list of military installations, but those, I mean, can potentially change. And it sounds like this tool is that's being proposed will get as close to kind of real-time feedback to see if you're in one of those areas. Is that sort of accurate?
Yes, I think it's intended to deal with, first of all, the installations and distances from installations that are listed in the appendix at the moment. But you're quite right. These lists could change in the future, and in fact, CFIUS has signaled that the Department of Defense will continue to develop these lists, and that the appendix may be expanded in the future to include, other facilities or properties of the U.S. government. But one thing to bear in mind, though, from the sort of certainty perspective, is that unless and until the rules are amended by a Federal Register notice that promulgates a revised or updated version of the appendix, we can be governed by the appendix as it exists at the moment.
Okay, great. Now, you had mentioned earlier that there are certain types of real estate deals that are subject to CFIUS review, and those are purchases, leases, and concessions. Can you tell us a little bit about that, particularly what is meant by concessions, and if there are any other criteria for CFIUS review?
Sure. So, in addition to the fact that the transaction must involve a purchase, or a lease, or a concession, the foreign person must acquire 3 of 4 specified property rights, and those rights are the right to physical access, the right to exclude others from access to the property, the right to improve or develop the property, and the right to attach structures or objects to the property. And it doesn't matter whether these rights are shared with a U.S. person, as long as the foreign person would obtain 3 of these 4 rights, and, as we've discussed, covered real estate is involved, then the transaction would be a covered real estate transaction. Now, with respect to the scope of the term concession, CFIUS in the new rules has defined this term to be a right granted by a U.S. public entity, so public entity, not a private entity, to use real estate for the purpose of developing or operating an airport or a maritime port. So again, we come back to the concept that's embedded in that first category of covered real estate, a lot of interest and concern about potential national security issues around acquisitions of property that is part of an airport or a maritime port. However, CFIUS again has signaled that the rules may develop and change over time, and pursuant to authorities granted by FIRRMA, which is the underlying legislation, the definition could be expanded in the future, to include development of oil and gas and energy generation facilities, for example. So again, we can be governed by the rules as they now exist, but I think it's helpful to note that the rules may change in the future, and it's important to watch for those changes, so that parties can plan accordingly on the requirements that might affect their transactions.
So in terms of talking about, say, a concession, then we're not necessarily limited to purchase and sale agreements and leases. It could be rights via, say, a license agreement.
Correct. As long as the package of rights that's granted by in your example, license agreement, meets the definition of concession that's in the rules, then yes, that would be a concession for CFIUS purposes. And that's a very good point, Gina, because one thing that I think parties often find is that in an industry, for example, the real estate business, you may use certain terminology in a certain way, and it's widely understood in an industry to have a certain meaning. But many times in the federal regulatory context, and the CFIUS context is no different, you'll find that the regulations specify a particular definition for a term that may not be completely on all fours with the common understanding of the term in industry. And so you always have to remember to look carefully at the definitions to see which terms are defined terms, and to make sure that you govern yourself according to the published definitions, as opposed to the sort of widely accepted industry meaning, if you will.
That's a great point. On our next slide, we're coming to our first CLE code that I had mentioned earlier in the introduction. The code is BH 2020-A, BH 2020-A. Just give you a second to get that down. So Barbara, maybe let's switch gears and talk about financing for a moment, because most of the real estate transactions that we see do have a financing component to them. They're purchased with some sort of mortgage loan, or financing is put on at some point. Are these types of transactions also subject to CFIUS review?
Good question, Gina. So generally speaking, no. Mortgages or other types of lending transactions are not automatically covered real estate transactions, but the regulations do specify that they may be covered if there is a significant possibility that the lending transaction could result in a foreign person gaining 3 of the 4 property rights that we discussed on the previous slide. And, that may be because there's a significant possibility that there will be imminent or actual default, or some other condition that seems, to create an imminent situation in which the foreign person might gain those property rights. And CFIUS has also signaled that in considering and determining whether a lending transaction is a covered real estate transaction, CFIUS will take into account whether the foreign person has made arrangements to transfer the ownership and property rights over the covered real estate to U.S. persons. Again, no sort of black and white, hard and fast answer to this question, but rather, as is so often the case in the CFIUS context, it's a question of looking at all the facts and circumstances and determining whether CFIUS feels that the criteria are met. These are situations in which the parties often find it valuable to reach out to CFIUS and have a conversation. If there's any doubt about the situation before proceeding with the transaction.
That would make sense. I could see a lender, not having the mortgage itself be subject to CFIUS review, but I could see a lender wanting confirmation that a party's received the safe harbor for a transaction which they might be lending on. Is there any kind of confirmation? Is there any documentation or diligence that a lender could request to confirm that? Meaning, what would what would the party actually receive to say that they fall within the safe harbor?
That's a good question. So we can talk a little bit about this now, and I think we'll also talk a little bit about the process later in the program. But generally speaking, at the end of its review, and depending on the type of process that's followed, the parties will receive a written communication from CFIUS indicating that the review has been concluded. They may or may not, depending on the type of filing that's done, receive a letter stating that they will receive the safe harbor. But certainly if they do, that will be presented to them in writing, and that letter is something that the people involved in the financing transaction might want to seek a copy of in order to have assurances that there's no possibility that CFIUS could come back and review the transaction post-closing and post-financing.
Yeah, I could definitely see that being a requirement. We often represent lenders as part of our practice, and we're always looking for new ways to get them comfortable. So that's really helpful. I understand that there are several exceptions to CFIUS jurisdiction. One of those would be acquisitions by what's called an accepted real estate investor. Can you tell us what that is and a little more about that?
Sure. So let's turn to that. That's an important exception, because, as I mentioned earlier, if the investor is an accepted real estate investor, as that term is defined in the regulations, then CFIUS would not have jurisdiction to review the transaction. Now, at the moment, the only countries of nationality that are applicable in the context of this concept are Australia, Canada, and the United Kingdom. CFIUS has signaled a willingness to engage with other countries and consider whether other countries might be added to the list. But for now, it's those three countries. But the analysis doesn't stop there, and there is quite a sort of long laundry list of additional requirements that have to be met in order to meet this criteria of being an accepted real estate investor. So the accepted investors include the governments of these three states. They include nationals of these states who are not also nationals of any other state. So let me give you an example just to make that very clear. If you had a real estate investor, an individual who is a dual Canadian and UK citizen, that person would still be subject to meeting all the other requirements, eligible as an accepted real estate investor. However, if you had a person who is a dual citizen of Canada and France, for example, then that person would not meet the requirement because they have dual nationality in a state that is not an accepted state for these purposes. Now, then, when you get into the question of entities, the entity investors, including all of their parent entities, must be organized in and have their principal place of business in either, one of these states, one of these three states, or the United States. And there's also a definition in the rules with respect to principal place of business. So generally speaking, the principal place of business is the primary location where an entity's management directs and controls the entity's activities. In the case of an investment fund, that would be where the fund's activities and investments are primarily directed by or on behalf of the general partner or equivalent. But, and this is an important but, if the entity has in some other government filing, and it could be a non-U.S. government filing, has asserted that its place of business, its principal place of business, is somewhere other than the United States or one of these states, then that principal place of business designation will sort of trump anything that you might creatively try to put in the CFIUS filing. So basically, something in an attempt here to make sure that parties do not try to have their cake and eat it too by sort of manipulating what they specify as their principal place of business, depending on the government filing in question. Now, entities must meet a number of other conditions as well in order to qualify for this accepted real estate investor status. The board of directors must be comprised as at least 75% of U.S. nationals or nationals of these three accepted real estate foreign states. And I'm using board of directors here as kind of a shorthand on this slide, but so board of directors or equivalent, if you will, board of managers, whatever it may happen to be. Any holder of 10% or more of the entity's voting rights, or rights to profits or to assets in the event of dissolution, or other sort of indicia of control must also be an accepted real estate investor. And for this purpose, CFIUS will aggregate interests of related parties or parties who've agreed to act in concert and so on. There has to be a minimum accepted ownership threshold that's met. And for entities that are publicly traded in the U.S. or Canada, Australia, the U.K., the threshold is the majority of the rights to vote, receive profits, or assets in the event of dissolution. And otherwise, the threshold, in other words, for privately held, non-publicly traded entities, the threshold is 80%. Now, in addition, the entity, and this, again, just a reminder, goes all the way up the chain of ownership, so this includes the parent entities, must not be listed on the U.S. Department of Commerce's entity list or unverified list. These are lists maintained by the U.S. Department of Commerce that specify, in the case of the entity list, entities with whom export transactions involving items subject to our export administration regulations may not be conducted. And the unverified list is a list that the Department of Commerce uses to identify parties to export transactions where they've been unable to verify that, for example, that the items have not been diverted inappropriately. And so, again, lists that are lists that identify various entities that, with respect to which the government has national security concerns. Then finally, in the past 5 years, the entity, and again, the entity, the investor entity itself, and any of its parent entities may not have been subject to enforcement proceedings in the U.S. Before a variety of agencies, Department of Justice, and then a sort of a laundry list of agencies that are involved in export compliance and economic sanctions compliance and so on. OFAC, state, commerce, energy, and so on. And then again, any entity that may have been subject to a divestiture order in a prior CFIUS proceeding would not be eligible for this accepted real estate investor status. Now, all of that sounds like a lot, and it is, but I think what I would say is that if you have an investor entity, let's say based in one of these three countries, if the entity at the top thinks that it can develop a structure that meets all of these requirements, without sort of segueing offshore to the Cayman Islands or some other country that's not an accepted real estate foreign state, why then it might be worth planning ahead, thinking about this a little bit, and determining whether this would be a useful concept and whether it would be appropriate to develop structures through which U.S. real estate investments could be made if the investor is focused on real estate that would fall within the covered real estate categories.
So, Barbara, if a client comes and says, I want to know whether I'm an accepted real estate investor, or I'm doing a transaction and I want to make sure the party on the other side fits within this exception, how do you help them with that?
Well, it really becomes a question of doing the due diligence, really, right up and down the chain of ownership of these entities. And, you basically need to ask a lot of questions about things like the composition of the board of directors and the shareholders, and sort of, like I said, go all the way up the chain. And make sure that you gather complete information, and then once you've got that all laid out, you can apply these various criteria at each level of ownership and determine whether you've got a buyer, a potential buyer who meets this exception.
Makes sense. Now, in addition to the accepted real estate investor exception here, I understand there are some additional exceptions given the nature of the real estate involved. Is that true?
Absolutely, and again, important to have an understanding of what those are. So, the first such exception relates to real estate that's within what the Census Bureau calls an urbanized area or an urban cluster, unless the real estate is within this sort of 1 mile proximity from a Part 1 military installation, or within an airport or maritime port, So again, that's something to watch out for. But be careful, because even though being in an urbanized area or an urban cluster would override proximity, the specified proximity distance to installations in other parts of the appendix, it would not override proximity to these Part 1 installations. Then there's a broad exclusion for single housing units, again, as defined by the Census Bureau, and this exception includes the fixtures on adjacent land that's that are incidental to the use of the land as a single housing unit. Another important exception is retail, trade, accommodation, or food sector establishments at airports or maritime ports where the terms of the lease restrict the use of the real estate for these particular uses. So if you've got a lease of a property in an airport, and your lease says that it has to be used as a restaurant, then with respect to that particular, a transfer of that lease to a foreign person, you would not have to be concerned that would be a covered real estate. Now, not say, and again, I emphasize this because you have to look at all the circumstances. If that retail lease, if that restaurant lease in that airport were held by a U.S. business that was being purchased, then you have to look at how the rules apply to U.S. businesses, and rather than focusing narrowly on the real estate holdings of the U.S. business. Going on to the next slide, a few more types of real estate that are subject to exceptions. Commercial office space, if the foreign person doesn't have an interest in more than 10% of the square footage of the business, or in which foreign persons would not represent more than 10% of the total number of tenants in the office space. Foreign air carriers that have leases or concessions relating to their activities, again, at airports and the like, are also accepted from these rules. And of course, that's because foreign air carriers and their access to U.S. airports are already heavily regulated by other U.S. government agencies. And then finally, land that's held in trust for American Indians, Native tribes, Alaska Natives, Alaska Native entities, and so on.
It seems like the exceptions are a big part of this and part of the analysis that needs to be done. Are there any other exceptions that apply here?
Well, I think one that's worth mentioning, and it's sort of not really an exception, but it gets back to what I said earlier about the importance of looking at definitions. So I wanted to, in that spirit, just speak briefly about investment funds in the context of real estate deals. When you come to look at the rules related to CFIUS review of acquisitions of U.S. businesses, there are certain mandatory requirements. In the context of those mandatory requirements, there are certain exceptions for investment funds that are U.S. controlled. There isn't really an equivalent in this real estate context, but of course, as I said at the outset, these real estate deals are not subject to mandatory filing requirements. However, there is one aspect in which a structure that involves foreign entities that might be or be part of the ownership structure of an investment entity could potentially be sort of excluded from CFIUS review, and that has to do with the definition of what's a foreign person and the definition of what's a foreign entity. And if a foreign, i.e. sort of an entity incorporated outside of the United States, is not traded on a foreign exchange, or it has its principal place of business in the United States, then that entity is not considered under the the CFIUS definition and structure of the rules to be a foreign entity, and it would only be a foreign person if it were subject to control by a foreign person. So for example, because it's owned by a foreign person, or because let's say the general partner is a foreign individual, and so it is possible to look carefully at structures. It's possible to have a structure whereby an investment fund has been created, say using a Cayman Islands entity, but in fact has its place of business here in the United States and is run by a U.S. general partner, for example. These are circumstances under which you might come up with a result that you sort of weren't expecting, and so again, for these reasons, it's worth looking carefully at the definitions and looking carefully at whether the particular investor entity and ownership structure that you're considering for a particular transaction does in fact trigger CFIUS jurisdiction. So I thought that might be worth mentioning.
For sure. We're coming to our second of the two codes needed for CLE credit. Please be sure to jot this one down. The code is BH2020-B. BH2020-B. Again, please just be sure to write this down. You will need it at the end for purposes of the questionnaire. So Barbara, I think you had started to touch earlier on the process. So assuming we have one of these transactions, we feel it's appropriate for CFIUS review, we don't fall within any of the exceptions that you've previously gone through, what are we looking at in terms of how we go about obtaining the review, and what are the timing considerations?
Okay, so a word about process then. The new rules provide for two different types of processes. One involves a filing called a joint voluntary notice. This has traditionally been the type of filing that was provided for by CFIUS. Then there's been a new concept introduced, which is called a declaration. And the declaration is a somewhat shorter document, but quite apart from the length of these documents, there are important differences in the length of the process involved and in the potential outcomes that may result. So with respect to the declarations, again, short form, 5 pages, and I'll say that's a little bit misleading because there's an online form that you have to utilize, but in many instances there will be information requested that will have to take the form of appendices and the like. So you will have to submit some attachments, things like the transaction documents and so on. And if the declaration route is opted for, then CFIUS has 30 days to review the declaration and provide the parties with an answer. So you sort of file 45 days prior to what you hope will be the closing date, and then CFIUS will make sure that your declaration is complete, and then from that point, they have 30 days, and so that 30 days may expire, in advance of the closing date, but you would still be constrained to hold off and close, um, so that there's always been at least the 45-day period before or between, filing and closing. Then on the voluntary notice side, a somewhat longer document, not an online form, but a paper filing that must contain contents that are prescribed by the regulations, and when there's a notice process used, CFIUS encourages the parties to file a draft ahead of time. Can often take, a couple or 3 weeks to review, for CFIUS to review the draft, for you to resolve any comments or questions that CFIUS may have. Although, obviously that process is designed to make sure that the actual review process, when the formal review begins, is able to proceed more efficiently and effectively because you've addressed these preliminary concerns. Again, so then once the formal filing occurs, you have CFIUS has a period of time again to make sure that the filing is complete, and once they've acknowledged the filing is complete, the initial review period, which is 45 days, kicks off. CFIUS can opt to initiate a subsequent 45-day investigation, which in turn, at least according to the regulations, can be extended by 15 days in extraordinary circumstances. And then, and let me assure you, you don't want to get to this stage if you because it would be a bad sign. But in a handful of cases, this has occurred over the years, where the CFIUS will refer the matter to the president, and the president then has 15 days to make a decision about whether to suspend the transaction. And so you can see just from comparing those two descriptions that the process involved in the declaration filing is quite a bit faster than the process involved in the voluntary notice filing. Although I will say that, and again, we don't have really experience under the real estate rules, which are only just a handful of weeks old, to look at sort of and in fact, CFIUS officials have said they're sort of not yet prepared to share statistics about how many filings they're getting and what kind of filings and so on. But under the old U.S. business review, acquisition review process, once CFIUS had the ability to extend that first review period to 45 days from 30, as it used to be in the pre-FIRRMA days, they have seen quite a substantial uptick in the percentage of cases that are resolved during that initial 45-day review period. So I think we could probably assume that you'll see a similar pattern under the real estate rules. So you've got the two different approaches in terms of the length of the filing. Each process involves a different length of time in terms of playing out, and then what are the consequences. So the options under a declaration filing, which is the shorter process, include the same sorts of things that could happen if you go the joint voluntary notice route. You could get a letter from CFIUS indicating that action under Section 721 of the Defense Production Act has been concluded, which of course would mean you would have a safe harbor. They could send you, however, they could send you a letter saying, we want you to file a full notice and go through the full, review and possibly investigation process. So that's a risk that you run if you take the shorter route right out of the gate. And then another option is that you could get a letter from CFIUS that says, we haven't had time to conclude action under Section 721, but we're not going to ask you to make a full filing. And so at that point, although they say, if you want to make one, you can. So at that point, you would not have achieved the safe harbor, but you may well conclude, based on the fact that CFIUS doesn't ask for a full filing, that the risk of being subject to review down the road would be limited. But the parties to each transaction are going to have a different sort of risk tolerance and risk profiles, and they'll have to make decisions based on how important it is to them to achieve that clear safe harbor. One other thing that I wanted to mention with respect to process, just quickly, because I don't think we have much time left, is that FIRRMA does authorize CFIUS to charge filing fees. The regulations currently do not provide for filing fees, but again, we're being told by senior CFIUS officials that there will be proposed rules coming out soon, again with no further specificity as to what soon means, but that we should expect proposed rules related to filing fees soon. So that's something to watch for in terms of CFIUS process related issues.
I think that's really helpful to note the timing as well as the potential filing fee for parties to be aware of, so they can negotiate those points into their transactions. I think you're right. We are coming up on the hour. We did want to see if there were any questions, though. I think we just have a couple of minutes left.
Yeah, there seems to have been a question submitted via email here, although I think we may have addressed it in the course of the presentation. And that question is, does the white list of countries also apply to real estate transactions? And of course, I think this questioner is referring to the list of accepted foreign real estate states, which are Canada, Australia, and the United Kingdom. And indeed, of course, these states do play into the definition of accepted real estate investor, and are the same list of states that play into the similar definition under the rules related to acquisitions of U.S. businesses.
Okay, great. I think we are at the end here. On behalf of myself and Barbara, we want to thank you for attending the presentation. We hope you found it informative. As I had mentioned at the beginning of the presentation, you will be receiving copies of all the slides on the presentation, as well as a recording of the webinar via email, so please look out for that. If you are applying for CLE credit, please make sure you stay logged in after the presentation is over to complete the questionnaire. And there is some further information on CFIUS and the rules that have been prepared by members of our team. Links to those will be included in the email that you receive. There'll also be information on an additional webinar that we're holding later this month regarding CFIUS. Also in the presentation, you'll have contact information for both Barbara and myself should you have any questions and wish to reach out to us. Thank you again for attending.
Thank you.